Jean Keating. Statutes are bonds. Courtroom charges are civil, not criminal. Clerk's praxis was the court of arches under the King's Bench at the time of Edward I. It's a court of probates. John Hall wrote this book. This was used in vice-admiralty courts in the colonies in the American Revolution, and this is what caused the Revolution. Everything involves bonds. When you are arrested, there are two different sets of bond. A bid bond is filled out when you are arrested. U.S. District Court uses forms used SF 273, 274, and 275. There is another set of bonds. Both sets are put out by the GSA. SF Form 24 is the bid bond. The performance bond is SF Form 25. The payment bond is SF Form 25A. These are all put out by the GSA. Under the controller of the currency, under the GAO, General Accounting Office. SF 273, 274, and 275 are the bonds for federal-level courts to use. What are they doing with these bonds? In the courtroom, you are being sued for debt collection. It is an action in assumpsit. The word, presume, comes from assumpsit. I agree or I undertook to do. Assumpsit means collection of debt. All these bonds have a penal sum attached to it. If you go into default judgment, you end up in prison wondering what is going on. If you argue jurisdiction or refuse to answer questions that the court addresses to you, you'll be in contempt of court and in jail. This goes back to Edward I. and Clerk's praxis. This is all civil and not criminal. It's a smoke screen to cover up what they are doing. They brought someone to court under an arrest bond. There was a civil suit. Clerk's praxis is Latin for practice. Praxis means practice. This book is an actual practice book that goes into everything Jack Smith teaches, letter rogatories. You are held until the suit is complete. They get a default judgment for failure to pay a debt, and then you are put in prison. Attorneys are there as a smoke screen to cover up what is really done. They lead you into default judgment by argument, dishonor. You go to prison, and then the default judgment is sold. U.S. District Court buys all the state court judgments. Type U.S. Court in any search engine. After you get to U.S. courts, there are 11 circuit courts of the U.S. listed. Click on Circuit 7, and that takes you into all the list of courts. To find Ohio-Illinois, find Circuit 7 is Northern Illinois District Courts, Bankruptcy Courts, etc., and then you'll find a box that says Clerk's Office. Scroll down and you'll see Administrative Offices, and under that you'll see Financial Departments. It talks about the Criminal Justice Acts, optional bids, it's all spelled out. Go to List of Sureties. Why would they have a list of sureties in a federal district court? When you click on this, it takes you to www.fms.trias.gov. This is Department of Treasury. Then you will see on the left-hand side of the screen admitted and reinsured. Under that is List of Sureties. Under that is Forms. If you click on Admitted, Reinsureds, there are over 300 insurance companies. There's a complete list. There's also a list of surety companies. These are more insurance companies. Under Circular 750, the Department of Treasury, these insurance company, have to be certified before they can purchase the bonds. They can't put up bonds unless they are certified by the Secretary of the Treasury. Next, you go to Forms. Click here, it goes to the Miller-backed reinsurance. It'll list 3 different type of bonds. You don't use a bid bond in district court. These bonds come out of the GSA. The 273, 274, and 275 bond forms are as follows. 273 is the reinsurance agreement with the U.S. 274 is the Miller Act reinsurance performance bond. 275 is your payment bond, the Miller Act reinsurance payment bond. What are they doing with these bonds? They have regulations governing these bonds. 2,000 pages governing these bonds. Jean will sell these for $50. If you go into these regulations, they tell you they're buying up commercial items, actual words. 2.0, one of these regulations. These regulations are divided into 50 parts. There are 1126 pages, Volume 1, 823 pages in Volume 2. Commercial items are non-personal property. Property that is not real estate, movable property. Real estate is not movable. These terms are defined in UCC. Commercial items are commercial paper. This is the 8th edition of Black's Law, which just came out. Commercial items, it's commercial paper, negotiable instruments. Anything you put your signature on is a negotiable instrument, lex mercantoria. This is used in the courtroom because every one of us is a merchant of law. Because I use commercial paper on a day-to-day schedule, I am considered an expert. This is why they don't tell us what's going on in the courtroom. Every time we put our signature on a paper, we're creating negotiable and non-negotiable instruments, and that makes us experts. When I endorse it under 3419, I'm an accommodation party or an accommodation maker. Anyone who loans his signature to another party is an accommodation party. This is in 3419 of the UCC. When you loan your signature to them, they can rewrite your signature on any document they want to. The federal courts buy up the state courts' default judgments. These are civil and just being called criminal to cover up what they are doing. If you don't pay the debt, you go to prison. CUSIP is an identification system. DTC Depository Trust Corporation, and has several other monikers. Depository Trust Clearing Corporation. $1 trillion a day goes through the DTC. Goft Clearing Securities Clearing Corporation is another day. CUSIP, Committee on Uniform Identification Processes, is a trademark of Standard & Poor's and is on bottom floor of the building at Water Street in Washington, D.C. CUSIP SINS, CUSIP International Numbering System, is an international numbering system. Domestic securities have 6-digit numbers. International number, ISID International Securities Identification Division Plus, are a global networking system. Payne Weber, with 10,000 corporations in it, is the major stockholder of CCA, Corrections Corporation of America in Nashville, TN. They have privatized the system. Ginnie Mae, Fannie Mae, HUD are all international. Everyone is feeding off the prison system internationally. All major corporations are feeding off the prison system, including REIT, Real Estate Investment Trust, PZN, Prison Trust. All real estate companies are holding bonds, and the bonds are not redeemed, and they haven't closed my account. Lehman Bros just gave $6 billion. New York City had a $3 billion deficit. Lehman Brothers gave NYC the money to build credit facility, not prison system. Lehman Brothers is underwriting the prison system. They buy up the bid bonds, the court judgments. There are international treaties that are reinsurance treaties. Insurance companies come in and act as sureties for the bid bonds. The performance, bid, and payment bonds are all surety bonds. All bid bonds must have a surety. The surety is guaranteeing the reinsuring of the bid bond by issuing the performance bond. They get an underwriter, investment broker, or banker to underwrite the performance bond, which reinsures the bid bond. The underwriter takes the payment, performance, and bid bonds and pools them into mortgage-backed securities, which are called bonds, and sold to TBA, the Bond Market Association, an actual corporation. After the payment bond is issued to reinsure or underwrite the performance bond, which reinsures the bid bond, the banks convert the bonds to investment securities. The banks and brokerage houses are selling these as investment securities. The prisoners are funding the whole enchilada, because you got into default judgment when you went into the courtroom. There are regulations governing these that are all in 48 CFR, Title 48 Code of Federal Regulations. This is where Gene gets all the information. It's on his $50 disc. Part 12 deals with commercial items, which are negotiable instruments, which are court judgments, the performance, payment, and bid bonds. Anytime you deal in bonds, you are dealing with risk management. A reinsurer and reinsurance means you are dealing in risk management. The reinsurer is assuming part of the risk of the bid bond. They give him a portion of the original premium. The original insurer gets part of the premium of the policy of the bid bond for acting as surety for the bid bond. The underwriter guarantees the resale of the bonds back to the public as investment securities. To win in court, you have to redeem the bond. Gene went to court and asked for his bid bond. He asked for post-settlement closure of the account. This process is hypothecation. You have to know how to hypothecate the bond. Banks make derivatives out of your promissory notes and sell them mortgages, credit cards, etc. These prison bonds are being monetized. They make an investment security out of it. They make a fortune off the prisoners. These bonds go international into SINS and then into ANA, Annual Numerical Numbering Association in Brussels, Belgium, with unlimited capital. This is where euro, yen, sterling, everything is under the prison system. All countries are feeding off it. This is what was behind 9/11. State legislatures pass bond statutes so they can arrest people for paper terrorism. American Legislative Exchange Committee is behind all this. Paul Warwick owns this think tank. ALEC promotes privatization of the prison system. They go to the National Congress of Commissioners, which are 72 judges and lawyers who grew up under the UCC under Lex Mercantoria. The principles of the law merchant are the rules of the decisions of all the courts. Everything is commercial. All crimes are commercial. All crimes: kidnapping, robbery, extortion, murder. You don't close the account, you go to prison. The bond gets sold domestically and internationally. The bonds are sold on the NYSE. CCA, Corrections Corp of America, sells their stock and shares on the NYSE. John D. Russell owns 64 million shares of CCA. John Ferguson, VP, owns 5 million shares. They are on the CCA board of directors. The Dillon Corrections Corp is owned by David Dillon and merged with Trinity Ventures Investment, who then became SB Warburg. That's part of the Warburg family, located in Chicago, Illinois. They are hooked up with the BIF Bank, the Bank of International Settlements in Switzerland, one of the largest banks in the world. This is why people do not win in court. Trial and pre-sentencing are just a dog and pony show. Don't use a bond, Jean says. Use a bid bond. It has the word principal. I am the principal, the strawman is the surety. Put the strawman as the surety and myself as the principal. Then I fill out a performance bond, which is a reinsurance bond for the bid bond. On the reinsurance bond, I will put myself down as the guarantor or the reinsurer. The performance bond is $274. The payment bond underwrites the performance. I can underwrite the bid bond with the performance bond. That's the reinsurer. The courts do this for me because I don't know this stuff, and then they make the money off me. If you have a case pending, go into whatever district you are in. Find the court, type in the case number, and it'll tell me who has my bond. Banks are all tied into this. Every time I sign a check, it's a promissory note. The bank makes a derivative out of it. The bank endorses it on the back, without recourse, and monetizes it by selling it as a derivative. They sell it internationally. My $100 check is used by 20 or 30 corporations internationally. This is why we are not getting back our canceled checks. The reason is they are sold as promissory notes. The banks make derivatives out of them and sell them internationally. Therefore, I am loaning money to the bank. The bank reloans it to other people. The CUSIP hash is a 9-digit number. Internationally, it's up into 12 digits, representing trillions of dollars. What if you have a court case in default? Default is synonymous with dishonor. They are suing you civilly for collection of a debt. If you go into default judgment, if you have a claim, they're mandatory Rule 13. Rule 13 says that when a claim arises from the same transaction or occurrence, it is mandatory that you file a counterclaim. What is your counterclaim? Post-settlement and closure of the account under public policy. You're entitled to a discharge of the debt because you are the principal and the holder in due course of the original account. You own both sides of the account. You own the common stock and the preferred stock, and you are the principal on the account, which means you are the creditor. Everyone is acting like a debtor instead of a creditor. A creditor pays his debts. You have to do the proper filing to establish your position. UCCI, you have to be the secured party. You are the principal upon which all money circulates. This is the accrual method of accounting. Accruals are capital and interest from the principal. Anytime you monetize debt, you have a principal. You have to identify yourself as the principal. What they have to do is return all the capital and interest to you as the principal. This is the accrual method of accounting. When you go to court and argue jurisdiction, what you are saying is you aren't going to pay the debt. The strawman, all caps name, is the name they have a claim against because your mother signed the birth certificate with the state creating the strawman contract. They used your name in all capital letters. That makes you the fiduciary trustee of the account, which means you pay all of your debts to honor the court. People in the redemption process are going into the court and arguing and getting into default judgment. If you don't give your name or argue jurisdiction, you're causing problems. What you can do is give a conditional acceptance. If they don't charge you, they don't have a claim against the strawman, but don't start arguing with the court about it. Do a conditional acceptance. I'll be happy to give me my name if you'll give me the charging paper. Rebut the presumption that they have charges against you. They work on presumption and they don't have to have anything. You have to rebut the presumption. Use a negative averment. The court is drafting you for performance. If you don't perform, you get into dishonor by non-acceptance. They make a formal presentment under 3.5, one of the UCC, in order to charge, and they use the word charge. They use the same commercial term on your indictments, complaints, your information. They use the word charge. The following charges: 2 counts of RICO, etc. Gene Keating and Roger Elvick both had the same charges. Roger has been in jail 9 months. Roger hasn't been to trial yet. Gene is out of jail. Roger is arguing jurisdiction. He's arguing whether they are an Article III court. They have a business credit report on you. If the judge says he's going to do a psychiatric exam on you, you're arguing. You have to be a gentleman and not get belligerent. Be gentle as a dove and wise as a serpent. If you act like a belligerent, they're going to beat you up. You're the fiduciary trustee and the principal and owner of the account. Following is Gene's overlay, notes in, not to be included in the overlay, just emphasis. Tell them what to do. You want full settlement and closure of the account. You have to do this from the get-go. I accept your charges for value and consideration. You must use value and consideration in return for post-settlement and closure of account XXXXXXXXX, social security number with no dashes. The CUSIP is the SS hash without the dashes. CUSIP and AutoTRIS, Automated Tracking Identification System, number. CUSIP is Uniform Security Identification Processes. CUSIP uses USS hash to identify you because the birth certificate is an investment security. All these are registered at state level with Department of Human Resources, then to Department of Commerce at federal level, and then to the DTC, Depository Trust Corporation on Water Street. CUSIP is a trademark of Standard & Poor. It is located under the DTC building at 55 Water Street in New York City. The 9-digit CUSIP is also used for ISID, International Numbering System. I accept the charges for value and consideration. In return, please use my exemption and principal for post-settlement and closure of case number, and CUSIP and AutoTRIS account 555,555,555, as this account is prepaid and exempt from levy. Then date it and place your signature it below the previous statement. The case hash references back to your SS. That's why they always get your SS hash. Endorse as the strawman by, authorized by, or agent with your signature. Write good as Aval after the signature. I'm the fiduciary trustee who is assuming responsibility for the strawman as the authorized representative. When you put the word by and then authorized representative, it means someone other than the strawman signed. Other way to do it is the real Christian appellation, and you don't have to put by. John Peter, public, under 34210 of UCC. If a person acting as a representative or purporting to act as a representative signs an instrument the name of the senior, the representative person is bound by the signature in the same extent a representative person would be bound by the signature on a simple contract. That is, you're not incurring any liability on the signature. Lynn's note. Look this up. The tape was hard to hear at this point. That's why you want to sign the strawman name and then by John Peter Public, authorized representative. What they do is they put the AutoTRIS hash in a manual in a module. Every federal and state agency has my tracking number. They have it in the criminal task force. Passports, Metro Police, City, County, Sheriff, FEMA, Homeland Security all use this. AutoTRIS was made in a forensics laboratory in Russia. It is owned by Ad and M, stopped between the 2 left arrows. He used this on an Ada and it worked. They held him for 3 days and let him go. Judges and attorneys do not understand commercial law. They don't teach it in law school. No one uses it in a courtroom. Nobody knows this stuff, and that's why Gene is teaching it. Because we are using commercial paper, the law assumes we understand what we are doing. You are responsible for your actions. If you use commercial paper on a daily basis, that makes you an expert by legal definition. They presume you know all this stuff when you go into a courtroom. The judges don't even know this stuff. If you don't show up in court with an attorney, they grill you about competency and mental capacity. Here, what you are dealing with, you are arguing with these people. You don't want to argue in a commercial setting. What you want to do, and the reason you have to have an attorney in a courtroom, is that they are working on the public side and you are working on the private side. Everyone on the public side is insolvent or bankrupt. You are dealing in Black's Law, a fiction of law. You are referred to legal fiction. Why do they call it legal fiction? Definition. This is the reason why you can't argue venue and jurisdiction in a commercial setting, assumption that something is true even though it may be untrue. In some aspects of admiralty, you can argue venue and jurisdiction, made especially in judicial reasoning to alter how a legal rule operates, specifically a device by which a legal rule or institution is divergent from its original purpose to accomplish indirectly some other object. The constructive trust is an example of a legal fiction, also termed a fiction of law, fictio juris. They will not allow you to defeat this fiction of law. This came out of Erie versus Tompkins, and courts at all levels are using fictions of law because everything is colorable and has the appearance of being rule, but it's not real. Jean worked with a case, used a habeas corpus, and the judge threw it out because Jean failed to give a colorable claim. How can you give color to a pleading? Confession and avoidance. Jean did a lot of research in this area. Confession and avoidance is a common law remedy. You avoid the consequences of the action by the plaintiff, and you avoid by defenses. This has been changed to Rule 8 concerning defenses, Federal Rules of Civil Procedure. Letter of affirmative defense, the law of discharge, the law merchant, the law of principle and equity, the law of satisfaction, the law of bankruptcy. Are they bankrupt? Sure they are. You don't want to rebut the presumption. You want to settle the account as the principal. When they monetize a debt, they always have a principal on which they borrow all this money. Trafficant said we were going through the biggest bankruptcy and reorganization in the history of the U.S. He's in jail because he dishonored the court. All these judges know there's no money. Under common law, only gold and silver is money. Title 12, Section 211 and 212, the lawful money of the U.S. is construed as gold and silver coin. Any Federal Reserve note is redeemable at any Federal Reserve Bank or Treasury office for lawful money. Title 31, Section 5118(2)d. HJR 192. They have to give you an out, a remedy. Affirmative defenses under Rule 8 is my remedy for every commercial liability. These are prepaid accounts. The industrial society borrows money to manufacture product, like General Motors. They are on the public side of the accounting ledger. On one side of the ledger, everything is private. The principal is on one side, the debtor strawman is on the public side. That's in the bankruptcy. You are the principal and the owner. You're the stockholder, you're the bank. This is not opinion, this is what is going on. Gene owns his own bank and drew up his own charter. You are the lien holder in this system. You own preferred stock and the common stock. The strawman is the beneficiary. Your exemption is in a bridge between the private side and the public side. That's why you have the exemption. Credits are liabilities and debits are assets. They can't pass from the credit to the debit side because we are constantly in dishonor. Debits are private and credits are public. They're borrowing all this money using our credit. I'm responsible for the strawman. The strawman name is on the complaint in court, and the strawman is liable and has to pay. If the strawman doesn't pay, I pay for him because I didn't assume the responsibility as the fiduciary trustee, and they sell the account. They don't need a real complaint or a real warrant. It's all colorable. They will not allow you to overcome them. You start arguing with them, not giving your name, they will drive you into submission and into contempt. Gene, done all this. You don't want to do this. They will kill you and collect the insurance money. I'm insured by the FDIC and the FDIA under Title 12 with a $10 million dollar policy. I'm worth more dead than alive. They'll kill you without batting an eyelash. They killed a young woman by shooting her in the face with a pellet after the Red Sox won, and she wasn't doing anything. The more people they kill, the more money they make. Judges and lawyers in Texas hired someone to shoot migrant workers, and then they collected the insurance money on them. This is serious business. What does a creditor do? Pays his debts. I am the only one with any money. The banks don't have money. Everyone on the public side is bankrupt. Everyone who goes into court and argues with the judge over how they spell their name, all caps, etc. When you have committed a felony, they will appoint counsel. What you do is a letter rogatory, a letter of advice. What goes in this letter rogatory? You instruct the attorney that you are doing an acceptance for honor, and you want an accounting of the total amount of the bill for full settlement and closure of the account, and you give the case, the CUSIP hash, and the auto tris. The letter rogatory is in clerk's praxis. What you say in the letter, you put your name in and I appoint attorney's name as my fiduciary trustee, case, auto tris, and CUSIP hash. Use my exemption for post-settlement and closure of this case and account. Date this and endorse it. I'm actually creating all the money for the bank. They make derivatives and fractionalize it and makes trillions of dollars off me. Gene issued an international bill of exchange for his APA parole officer, and they stopped billing him. They closed the account. He's going after the bid bond, the performance bond, and the payment bond. He wants them back. He's the principal, and he wants his capital and interest back. After he did the international bill of exchange, they arrested him and then let him go after 3 days. They quit billing him the weekly parole bills. Dec 8, 1988, the U.S. became a party to the Municipal Convention on the International Bills of Exchange. They have insurance on the strawman, and when you go in as an insurgent or belligerent. There is the War Powers Act and Trading with the Enemy Act, and you are subject to seizure wherever they find you. If you don't allow them settlement and closure, they will kill you without batting an eyelash. Don't fire the attorney. Tell the judge that you are appointing the attorney as fiduciary trustee. When you go into court, you have to be a gentleman and don't get vulgar. If you do things right, you will not be held in contempt of court. Gene was charged with 3 counts of RICO, felony 1, 2, and 3, including intimidation. The only reason he spent any time in prison was that he couldn't get his paperwork. He served 5 months. They dropped the first 2 counts. They arrest you, and what you want to do is go after the bid bond. There are 2 sets of bonds, the GSA 25 SF standard form. There are 2 sets of forms 24, bid bond 25, performance bond 25A is the payment bond. Municipal Convention supersedes Article 3 of the UCC. This is in the official master text of the UCC.